Hello, good evening, and welcome to BYJU'S Exam Prep. Welcome to yet another episode of Polity This Week. And it gives me immense satisfaction to share with you that this weekly initiative has completed 1 month. During this short period, if these weekly lectures have been of some or any help to you, please let me know in the comment section. Favorable, unfavorable, critical, but please let me know. And if it is all favorable, don't forget to press the like button as well. These are the topics that we shall be discussing today from sources such as the Hindustan Times, the Hindu, the Indian Express. Let's get started with this episode and look at topic number 1. What is the background? One advocate of Madras High Court, Miss Victoria Gowri, she was recommended by the Supreme Court Collegium to the government for appointment as the judge of the Madras High Court. When her name came out, a petition was filed in the Supreme Court challenging the elevation of this advocate to the Madras High Court. Why? Because it was alleged that she has indulged in hate speech in some of her previous interviews and speeches. She has allegedly made hate speeches against the minority communities. It was also alleged that she was once the member of the BJP. All this raises 4 or 5 important questions, and let's discuss all these important issues one by one. The first is, Miss Victoria Gowri, an advocate of the Madras High Court, was recommended by the Supreme Court Collegium to the Madras High Court as the judge of the Madras High Court. But from the same High Court, another advocate's name was also recommended by the Supreme Court Collegium to the Madras High Court. And the name of this individual advocate is R. John Sethiam. But when his name was recommended to the government for appointment, his name was not approved by the government. Why? It was argued and it was alleged that he has tweeted an article which was published on the Quint.com, which was critical of the Prime Minister Modi. And at the same time, he had also tweeted something questionable when a girl from Tamil Nadu who had failed to qualify the NEET examination and she had committed suicide. It's because of these 2 reasons that the Intelligence Bureau had raised concerns, flags on the appointment of this advocate of the Madras High Court as the judge of the Madras High Court. But the same Madras High Court has another practicing lawyer who is Miss Victoria Gowri. Her name was recommended to the Madras High Court by the Supreme Court Collegium, and the government showed tearing hurry in clearing her name, and she was appointed as the judge of the Madras High Court. What is the issue that this particular controversy raises? Number 1, because of the judgment in 1993, because of the judgment in 1998, because of the judgment in 2015, what is famously known as the second judge's case, third judge's case, fourth judge's case. It was in 1993 in Sakara versus Union of India, Supreme Court's Advocates on Records Association versus Union of India, that Supreme Court invented collegium system, making India perhaps the only country in the world where judges are appointed by themselves. So the Supreme Court Collegium will recommend names to the government. The government only has to issue a formal appointment letter to be appointed as the judge of the High Courts and the Supreme Court. It was argued that this collegium system will prevent the interference of the executive. But despite collegium system, we still see that if the government of the day will get its own nominees appointed to the judiciary, then independence of judiciary, despite collegium system, is getting diluted. Because one name from the same High Court was recommended and approved by the government, the other name recommended by the collegium to the government was not approved. That's number 1. Number 2, the entire collegium system smacks of opacity. There is a lot of opacity in how the Supreme Court Collegium discusses names and recommends these names to the government for appointment. This entire process lacks transparency. How? In India, when do we get to know that a particular person's name has been recommended to the government for appointment to the judge of High Courts or Supreme Court? We get to know at the time when the Supreme Court sends this recommendation. That means only at the recommendation stage, but not at the consideration stage. When the Supreme Court collegium is considering few names or some names, we have no idea who are these individuals being considered for appointment. We only get to know when these names are recommended to the government for appointment, which is unlike what happens in other democracies such as the United States of America, such as Kenya, such as South Africa, where people get to know at the consideration stage who are these names being considered for appointment to the higher judiciary. If the same transparency was shown by the Supreme Court collegium as well, maybe the Supreme Court collegium would have got to know about the alleged hate speeches being made and delivered by this particular advocate, and then maybe the Supreme Court collegium would have conducted a face-to-face interview with Ms. Gowri, asking her, what is your take on these allegations? So that Supreme Court collegium, apart from judging the eligibility, would also judge the suitability of a candidate for appointment. Because was and is Ms. Gowri eligible to be appointed as the judge of the High Court? Yes. Because what is the eligibility? You should be the citizen of India. You should have held a judicial office for 10 years. You should have been an advocate in one or more high courts for 10 years. So definitely she is eligible to be appointed as the judge of a high court. But was she suitable? What is her constitutional philosophy? What is her take on these alleged hate speeches that she has made? Then this face-to-face interview would have resulted in such a situation where collegium would not have been embarrassed before the public in India. That's number 2. Number 3, something very important. Is political affiliation a ground for disqualification? Does that mean if you belong to a particular party or if you are supporter of a particular political party, that renders you ineligible or unsuitable to be appointed as the judge of the High Courts or Supreme Court? No. Why? Political affiliation is definitely not a disqualification, but bigotry is. That's a key question. Look at Justice V.R. Krishna Iyer. Have you heard of this name? His judgments are cited by the International Court of Justice. His judgments are cited even today by the Supreme Court of India. He played a very important role in Maneka Gandhi versus Union of India in 1978, where Supreme Court said procedure established by law is basically due process of law, which means the law passed by the parliament has to be just, fair, reasonable as well. Because right against arbitrariness is also a fundamental right. It was in this judgment that Supreme Court said principles of natural justice are also found in the Constitution. It was Justice V.R. Krishna Iyer who basically implemented the public interest litigation in India, opened the doors for larger public to approach the Supreme Court for the violation of fundamental rights. So PIL in India is one of the gift of V.R. Krishna Iyer. But who was V.R. Krishna Iyer? He was a politician before he became the judge. He was a member of the Legislative Assembly of a state. Under the communist government in Kerala, he was a minister for home, he was a minister for law as well. Once EMS Namboodiripad government was dismissed by the central government in 1957, he joined the bar again, and then he was elevated to the High Court and then to the Supreme Court. So political affiliation is not a disqualification, but bigotry is. Why in India? Look at the United States of America. One particular individual, Justice William Howard Taft, he was the 10th President of the United States of America, but he was also the 27th Chief Justice of the United States as well. So political affiliation does not mean that you are disqualified from occupying a judicial office, but bigotry, hate speech definitely is a disqualification. And the fourth important and troubling issue is this. Chief Justice of India is basically the head of the Supreme Court, and the Supreme Court has the power of judicial review. So when Miss Victoria Gowrie's elevation, a petition was challenged, petition was filed in the Supreme Court challenging her appointment, the judges of the Supreme Court did right thing, dismissing this petition. So it was basically right. Why? Because it was a challenge. The court would have only looked at whether she was eligible or not. She definitely was eligible. But whether she was suitable for a post or not, that is for the Supreme Court collegium to decide. And when they have decided, two judges cannot overrule the judgment, cannot overrule the recommendation given by collegium. And this is where it becomes even more interesting. Collegium, in order to appoint the judge of a high court, consists of Chief Justice of India plus two senior judges of the Supreme Court, correct? And at the same time, this Chief Justice of India is also the master of the roster. What do we mean by master of the roster? Chief Justice of India gets to decide who is this judge who will hear a particular case. So if there is a case involving election disputes, who are these judges who will hear this case? Who are these judges who will hear criminal cases? Who are these judges who will hear tax-related cases? So the Chief Justice of India, being the master of the roster, will allocate responsibility and role to other judges of the Supreme Court. Now in all these three things, here Miss Victoria Gowrie has been recommended to the government for appointment as the judge of the High Court. Now if this is an unfair recommendation, you have to challenge it in the Supreme Court. But in the Supreme Court, which has the power of the judicial review, Chief Justice of India is the head, who has recommended her appointment, Chief Justice of India and two senior judges of the Supreme Court, who allocates responsibility to a bench that you will have to hear this case, Chief Justice of India. So in all these three things, it is the same individual who is responsible, which primarily means there are no checks. That is the troubling question that is raised because of the appointment of Miss Victoria Gowrie as the judge of the Madras High Court. So it is advised, it is recommended that collegium should function in transparent manner so that every single individual, so that the larger public will get to know who are these individuals being considered for the post of a judge. On what basis are they recommended? Do they conduct these interviews to judge the suitability of a candidate? Do they test the judicial philosophy or the constitutional philosophy of these candidates? We have absolutely no idea. Sunlight is the best disinfectant, which means there has to be transparency in the functioning of any institution. And one such institution which requires transparency in its functioning is the Supreme Court Collegium. That is what you need to understand from this topic. Let's look at topic number 2. Opposition's call for JPC probe continues to stall Parliament. Now, there are two important issues which are raised by this matter. One is, what is this JPC? As the name suggests, Joint Parliamentary Committee, which means a committee which will have members of both the houses, Rajya Sabha as well as Lok Sabha. This JPC is an ad hoc body. That means it's for a temporary period, for a specific purpose, and created for a specific duration. Once that purpose is solved, this joint parliamentary committee is dissolved. So it's not a permanent committee of the parliament, it is an ad hoc committee of the parliament. That's number one. Number two, how is this JPC created? This JPC is created when a motion is passed by one house and this motion is approved by the other house. For example, a JPC is to be constituted. Lok Sabha will pass a motion by simple majority. This motion should be agreed by Rajya Sabha by simple majority. Or reverse, Rajya Sabha will pass a motion by simple majority, should be agreed by Lok Sabha by simple majority. And this is how this joint parliamentary committee is created. That's one way in which JPC is created. There is another way. The two presiding officers will write to each other to set up a joint parliamentary committee, which means the Speaker of the Lok Sabha will write to the chairperson of the Rajya Sabha, or chairperson of Rajya Sabha will write to the Speaker of the Lok Sabha and set up a joint parliamentary committee on a particular issue. What is the mandate of this committee that this motion decides? What should be the composition of this committee that this motion decides? What should be the purpose of this committee that this motion decides? For example, the first JPC was constituted, can you tell me, to look into the Beaufort scam. Then again, the second JPC was set up to look at the stock market scam, Harshad Mehta scam. 2001, another stock market scam was to be looked into by a joint parliamentary committee, Ketan Parekh scam. And then again in 2003, to look into the issue of pesticides in soft drinks, another joint parliamentary committee was set up. Why are we discussing it now? So that you should have an idea how many JPCs have been constituted in India since independence, since the time of the commencement of the constitution. Close to 6 to 8 JPCs have been set up. So the question can be in the examination that the number of JPCs is more than 10 constituted in India after the commencement of the constitution. So you should know this is an incorrect statement. But we are discussing this for one more reason. In 2001 and 2003, both these joint parliamentary committees were set up when this motion was introduced in Lok Sabha, passed by Lok Sabha, and then agreed to by the Rajya Sabha. But this 2001 stock market scam or Ketan Parekh scam, which was to be looked into by the JPC, it consisted of 30 members. Out of these 30 members, 20 were from Lok Sabha, 10 were from Rajya Sabha. But when a JPC was constituted, which was headed by Shri Sharad Pawar in 2003 to look into the issue of pesticide component in the soft drinks in India, it consists of 15 members. And out of these 15 members, 10 were from Lok Sabha and 5 were from Rajya Sabha. So if there is a question in the examination that the number of members of a JPC is always fixed, which is 30, you should know that this is an incorrect statement. Because the motion on the basis of which a joint parliamentary committee is set up, it is this motion which decides what is going to be the composition of this JPC as well. Not only composition, what should be the mandate of this JPC as well. For example, when this stock market scam JPC was constituted in 2001, this JPC was given a mandate that you should look into financial irregularities, that you should look into fixing the responsibility, that you should also identify what are the regulatory loopholes as well. So what is the mandate of this committee? What is the composition of this committee? What should be the duration of this committee? That is all decided by the parliament. So this is not fixed for all. It is an ad hoc body set up for a specific purpose, set up for a particular duration. Once that purpose is solved, then this committee is disbanded. So it is not a permanent committee of the parliament. But at the same time, whatever report is given by this committee, it is not binding on the government. When it is not binding on the government, then this committee will ask government, what is the action that you have taken on our recommendations? That is what we call action taken report, ATR. So this joint parliamentary committee will ask specific questions to the government that we have given you these recommendations. This is the report. What is the action that you have taken on these reports? And that ATR will be submitted to the parliament so that parliament have an idea whether some purpose was solved by setting up this committee. That's another key issue. But another issue is something related to Rajya Sabha, Rule 267. What is this Rule 267? For example, on the 1st of February, we launched our 2024 batch for the civil services aspirants. And we have given a proper schedule that for the entire year, this is how we will conduct these live online classes. So in the morning, I teach the polity, and in 24 classes for 3.5 duration, we will complete Indian polity syllabus. So in 24 classes, what is that? That is our agenda. That is our business. That means for these 24 classes, we will complete the Indian polity. What if something urgent happens? An important judgment of the court, an important development in the political sphere, an important law is passed by the parliament. Can a student tell us that you suspend the schedule for one day so that we discuss this important current affairs topic, so that we discuss this important law which was passed by the parliament, so that we discuss this important judgment given by the Honorable Supreme Court? Similarly, there is the agenda of the House and Rajya Sabha. What all do they have to discuss on a particular day? Under Rule 267, a member of the Rajya Sabha, with the permission of the chairperson of the Rajya Sabha, what will happen? This agenda, this business of the House will be suspended so that we discuss a matter of urgent public importance. That is what we call Rule 267. But this Rule 267 has not been used, invoked for a long time now in India. Between the period 1990 and 2016, 11 times Rule 267 was invoked in Rajya Sabha to discuss a matter of urgent public importance, suspending the normal business of the Rajya Sabha. The last such discussion on Rule 267 took place when the then chairperson of Rajya Sabha, Shri Hamid Ansari, allowed this rule to be invoked, and the Rajya Sabha discussed demonetization. Repeatedly, the opposition in Rajya Sabha is seeking the permission of the chairperson of Rajya Sabha that you should please invoke Rule 267. Let us discuss a matter of urgent public importance, an important matter, by suspending the normal business of the House. But since 2016, no such rule has been invoked, no permission has been given. That is why activists, writers, and those who look into the affairs of the Constitution and Parliament, they say that Parliament's control over the executive is weakening day by day. No JPC is constituted, no discussion under Rule 267 has taken place. So it all leads to a conclusion that the Parliament is now weaker in exercising its control over the executive. These are the two key things that you have to look into and understand from this topic. Opposition's call for JPC probe continues to stall the Parliament. Clear? Let's look at another topic taken from the Hindustan Times. Death sentencing law in India needs a rethink. What is the issue? It was 2022, last year, that a 3-judge bench of the Supreme Court referred a matter to a constitution bench of the Supreme Court, to a 5-judge bench of the Supreme Court. What was this matter? For example, you are accused of a crime. This matter will go to the trial court. Trial court will have to decide by looking at the evidence whether you are guilty or not. And now the trial court has pronounced you guilty. Now when you are a convict in this particular case, when you have been convicted for this crime, then we have to also look at the sentencing. That means now, since you are accused in a particular crime, now the trial court has decided, yes, you are guilty. Once you are convicted, now the court will have to decide what should be the quantum of punishment. Whether you will be given 7 years in jail or 10 years in jail or life imprisonment or death, that this trial court has to now decide. But normally, there should be a delay. Delay in the sense, these things should happen on a separate day. That means if today you are pronounced guilty, on the same day, quantum of punishment should not be announced. That means there should be some delay. on a separate day, the quantum of punishment should be announced. Whether you are subjected to sentence to life imprisonment or death, this should take place on a separate day. Why? There's a background. What is the background? Section 235 of the Criminal Procedure Code. What does this section say? That if, for example, you are accused and you are convicted, the judge will hear the accused on the question of sentence and then pass the sentence. That means the judges, when I have pronounced that you are guilty, I have to now hear you. After hearing you, after hearing the guilty, then I have to pass the sentence. Clear? Number one. Number two, Section 354, Clause 3. What does it say? It says if you are subjected to life imprisonment, sentenced to life imprisonment, or you are sentenced to death, then what the judge has to do? The judge has to give reasons as well. If I'm sentencing you to life imprisonment, why? Why not 10 years in jail? Why not 7 years in jail? Why not fine? But if I'm sentencing you to death, I have to give special reasons for this sentence. What is the special reason on the basis of which I am granting you death sentence? The combined effect of both these clauses makes it clear that there should be a time gap between the date when you are convicted and the date when you are pronounced the quantum of punishment. Why? Because in the year 1980, and listen to me carefully, one of the landmark cases in the history of independent India, Bachchan Singh versus State of Punjab, the Supreme Court said mandatory death sentence is unconstitutional. If there is a law which says that for this crime you should mandatorily be awarded death sentence, it is unconstitutional. There is no such thing as mandatory death sentence. Death sentence can be awarded only in the rarest of the rare cases. But what are these rarest of the rare cases? That is left to the discretion of a judge. And I'll tell you there is a significant problem with this doctrine. But I'll tell you slightly later. That's number one. Number two, the Supreme Court said in Bachchan Singh case that whenever an accused is to be pronounced guilty and now the punishment is given to this accused, the judges, what they have to do, they have to draw a list. The list of mitigating circumstances. Listen to me carefully, this is very, very interesting and important. The list of aggravating circumstances as well. What is this list of mitigating circumstances and aggravating circumstances? The Supreme Court said in Bachchan Singh case 1980 that death sentence, mandatory death sentence is unconstitutional. That means the judiciary will have to award capital punishment only in the rarest of the rare cases. Now, which are these rarest of the rare cases? You have to award death sentence in that case in which the provision or the scope for life imprisonment is unquestionably foreclosed. That means if there is a particular crime and for this crime, for this punishment, we will award you life imprisonment, that would be injustice. There should be something unique in this case. It should fall under this category of the rarest of the rare. If there is something rarest of the rare in this case, only then you can award capital punishment, death sentence. Otherwise, you have to award life imprisonment. So that means judiciary has to draw a list of mitigating circumstances which speak in favor of accused, and a list of aggravating circumstances which go against the convict, against the accused. Aggravating circumstances. For example, is there something unusual about a particular crime? For example, the Nirbhaya case, December 16, 2012, when in a moving bus, this innocent physiotherapy student was gang raped in a moving bus, and then she was thrown out of the bus, and this bus also toppled her. The point is, there was something unique, something horrible about this case. She was gang raped by 5-6 people in such a manner that an iron rod was inserted into her private part, which also ruptured her intestine. So there was something grotesque about this crime, something horrific about this crime. So when these circumstances are communicated to the judges are told, look at these unusual circumstances in this case. This was conducted in the horrific manner. So this is the list of aggravating circumstances which aggravate the crime. And that is why death sentence should be awarded to them. But what are these mitigating circumstances which speak in favor of the accused? This person committed this crime, but this person committed this crime or this murder because his family was in a dire condition. They haven't eaten for 10 days. And for that reason, he needed something for his family to feed. That is why he committed this murder. That does not justify murder. But look at the conditions. Look at the circumstances in which this murder was committed. That means these circumstances go in favor of the accused. That doesn't mean we will set you free. That only means that death sentence will not be given. Life imprisonment will be given to you. So that is what the Supreme Court said in Bachchan Singh case, which primarily means that if you are pronounced guilty, then what should happen? There should exist some delay so that on a next date, the judiciary should pronounce the quantum of punishment by looking at these mitigating circumstances and aggravating circumstances, so that the judges should get to know the accused. Under what circumstances did this accused commit this crime? That is why there should be a delay. Sentencing on a different date. Quantum of punishment on a different date. That means you are to be pronounced guilty today, but there should be some delay. After a few days, after some time, then the court should decide the quantum of punishment. And this rarest of the rare case has all the ingredients of a roulette table. We don't know if your case goes before a bench, before a judge who is not in favor of capital punishment, he will award you life imprisonment. But if this case goes before a judge who is in favor of capital punishment, this judge may award you capital punishment. Does this not smack of arbitrariness? And that is why Justice P.N. Bhagwati, former judge of the Supreme Court, he asked a very important question. He said, am I to live or die depending upon how benches are constituted from time to time? If my case goes to a bench who believes in capital punishment, I will be awarded death sentence. But if the same case goes to a bench which does not believe in capital punishment, I will be awarded life imprisonment. Is this not arbitrary? Does this not give enough discretion to a judge? Is this not violative of the fundamental right to equality guaranteed to me by the Constitution under Article 14 of the Constitution? It also raises another issue, that this rarest of rare case, there has to be some debate on this so that we remove the discretion which is given to a judge. And that is why this Constitution bench, which is now hearing this matter, maybe what it will do, it will give an opportunity. It will lay down rules and regulations that the judge, before giving the quantum of punishment, should know the accused. Maybe we will have to seek the help of psychiatrists. Maybe we have to check whether there is any possibility of reform in this individual. Because what is the golden rule of criminal justice system? Golden rule is that the objective of punishment is, one, to deter future commission of crimes, so that we award punishment so that it deters others from committing this crime. And number two, it should also reform the offender. The golden rule of criminal justice system is we should give punishment to somebody so that it is able to reform himself. Maybe this Constitution bench will look into these circumstances, will try to know this accused and see, with the help of behavioralists, with the help of psychologists, whether there is any scope of reform or not. Maybe, what are the social conditions from which this accused came from? Was there a family history of domestic violence? Was there a mental issue in the family? That does not justify his crime, but that can only mean that these are the mitigating circumstances under which we can say that this is not the rarest of the rare case. We will not award capital punishment. We will award life imprisonment. And that is why this column says death sentencing law in India needs a rethink. That is what you need to understand from this topic. And now let's look at topic number 4. In Assam, Beti, Padhao, written by Mr. Faizan Mustafa, who was previously the Vice Chancellor of Nalsar University of Law, Hyderabad, is an important constitutional expert. Khushbu, she was married in 2012 when she was less than the age of 18, which means it was a child marriage. There is a law, Prohibition of Child Marriage Act 2006, which says a marriage of a girl less than the age of 18 falls under this category of child marriage. And if you have violated this law, 2 years of punishment or 1 year in jail, or 2 years in jail, or 1 lakh as fine. 2 years punishment, 1 lakh fine can be imposed on the accused. Or it can be both, 2 years in jail as well as 1 lakh in fine. Khushbu, she was married when she was less than the age of 18 in 2012. Then during COVID-19 lockdown, she lost her husband. She is now a young widow. Then what happened? Her father was arrested by the Assam police. And then Khushbu allegedly committed suicide. Why? Because in Assam, a drive has been launched by the Assam government to tackle this menace of child marriage, under which those who have violated this law, they are being arrested. And according to the latest number released by the Assam Chief Minister, 2,789 arrests have been made. Child marriage is a menace, should be tackled, should be eradicated because it affects the educational opportunity of a child. If you're married off at a young age, which means we are depriving you of educational opportunities. When we are depriving you of educational opportunities, it also means that you will now be financially dependent upon your husband or his family because you will get no job. It also adversely affects the mental and physical health being of this girl as well. Also, the newborn will also be adversely affected because if the mother is not mentally and physically well off, mentally or physically strong, then it will also affect the newborn as well. So child marriage is a menace which must be eradicated. But is coercive police action, arrests, detentions, throwing them in the jail, is that the answer to solve this menace of child labor? According to 2011 census, close to 44% women in Assam, they are married before they complete 18 years. This percentage is 46 or 47 in Rajasthan. This percentage is 46 in Bihar. So despite the law which prohibits child marriages are still rampant if we look at the statistics released according to the 2011 census. Why? Because these child marriages have got a religious sanction. What is the religious sanction? For example, in Islam, a girl can be married, a boy can be married when they attain puberty, which means when they are capable of sexual reproduction, which can be age 15 or above. Despite the fact that minimum legal marriageable age for a girl is 18, for a boy is 21. But according to the Muslim personal law, you can be married at the time of the puberty, which can be 15 years or above as well. And recently, Punjab and Haryana High Court said that a Muslim girl's marriage above the age of 15 is still valid, even if you violate the 2006 Prohibition of Child Marriage Act. That's number one. Number two, according to the writer, Faizan Mustafa, not me, according to the writer, according to Manu Simriti, the father has to find a groom for a girl once she attains the age of puberty. If within 3 years of attaining puberty, if the father is unable to marry this girl, then this girl has the liberty to choose her own groom, according to Manusmriti. According to various travelers who traveled India during the ancient time, for example, Al-Biruni, Megasthenes, all of them have documented that child marriages in India are rampant. And if they are rampant, that means they have religious sanction. And to tackle a social issue, law is not effective. Because if the law was effective, then what about the 1961 dowry prohibition law? Despite this law, dowry is still rampant in our society. So law is not the only way in which you solve or tackle a social issue. Then what is needed? What is needed is educational opportunity to the girl child. What is needed is financial empowerment of the girl child. What is needed is mass awareness that child marriage is a menace which should be uprooted from the society. And that is what Faizan Mustafa writes in Assam. What we need is Beti Padhao. And once that Beti is taught, given education, given literacy, given financial independence, then it will automatically see that the child marriages will reduce to a large extent. And for that, let's take the example of Rajasthan. In Rajasthan, child marriages are rampant. Child marriages, for example, amongst the Banjaras. There is something known as chari. There is a boy who pays some price, some money to the girl's family, and then the marriage takes place. If this girl or the family, they withdraw from marriage, then hefty fine has to be paid by this girl's family to the boy. Why child marriages are rampant? Because unfortunately, a girl child is still viewed as some kind of an obstacle, some kind of dependent on the family. Because of poverty, they would need to marry this girl at a young age so that we don't have to pay dowry at a later stage, so that we can take the money from the boy's family and marry her off. Chari. Something else. Ata Sata amongst the Banjaras. What is that? Here is a boy and sister. There's another family, boy and the sister. They marry in each other's family. And most of these marriages are child marriages. Then there is something else. Maut ka khana. There's a feast organized in the honor of the dead. And then this bereaved family, where there has been a death, this bereaved family has to give feast, has to make others eat. Not only their relatives, but also the members of the village, and also members of the adjoining village. And at this Maut ka khana feast, there are child marriages rampant. That's Banjaras. Why? Because they're poor. Why? Because they do not have access to quality education and they are financially dependent. But contrast this with the Meenas of Rajasthan, who are also having a status reservation under the constitution, reservation under the law. But Meenas, the girls belonging to the Meena community, they don't drop out from the school. We don't see child marriages there. Why? Because majority of these families from the Meena community, they have a family member in the police or in the army or in the bureaucracy, because of which they are able to give their girl child quality education, give them financial support as well. So they are not poor. So this poverty is the reason for child marriages. So we have to tackle poverty. And that cannot be tackled when you are arresting people who have violated the law, because law cannot be the solution to a problem which is basically a social issue. And at the same time, this law also should be, clear. Clarity in the sense, there is section 375 of Indian Penal Code, which previously said sexual intercourse by a man with his wife who is 15 years of age, 15 years to 18 years of age, it is not rape. It was only in 2017 in a landmark case, Independent Thought versus Union of India, that Supreme Court said no, sexual intercourse with a wife who is less than the age of 18, despite your marital status, it is still a rape. It is a rape, and you will be punished under this. So the law previously was not clear. Even this Prohibition of Child Marriages Act, even this is not clear. What does that mean? Are these child marriages, what is their status? If the minimum legal age for marriage is 18 for a girl and 21 for a boy, now even if a child marriage is committed, child marriage is organized, what is the status of that marriage? Is that marriage invalid? No. Is that marriage void? No. Is that marriage voidable? Yes. What's the difference? Triple Talaq law passed by the Parliament in 2017, which says even if the husband is pronouncing triple talaq, saying talaq, talaq, talaq 3 times in a single utterance, it does not lead to divorce. That means divorce will not take place. And if you indulge in this, we will sentence you to the jail. But the Prohibition of Child Marriages Act, what does it say? Child marriages are legal. Child marriages are not illegal. Child marriages are not void. Child marriages are voidable. Which means if the child marriage has been committed, I am a girl less than the age of 18. Now a child marriage, I was forced to commit and enter into this wedlock. Now within 2 years when I attain puberty, or within 2 years when I become an adult, that means till the age of 20, I can approach the court to declare that this marriage is invalid. That means child marriages per se, these are not void, these are not illegal. There is still legal status given to these child marriages. But you can declare these child marriages invalid if a girl petitions the court that please declare this marriage invalid because I was a child when this marriage was solemnized, when this marriage was convened. What law requires is that you should say in this law that all child marriages are illegal. When they are illegal, that means there is no legal sanctity to this marriage. And that is why we say, one, law cannot solve a problem which is a social issue, plus law itself should be clear. And what we need to tackle this menace of child marriages, we need education. Through education, we need employment opportunities because poverty is the single most important contributing factor for child marriages. And that is why the author says in Assam, Beti, Padhao. That is the solution to child marriages. Let's look at some of the questions now. Consider the following statements. A joint parliamentary committee can only be created based on a motion passed by one house of the parliament and agreed to by the other house. This is not the only way in which a JPC is created, because JPC can also be created when the presiding officer of one house writes to the presiding officer of the other house. So this statement is incorrect. The strength of a JPC has to be 30 members with 20 from Lok Sabha and 10 from Rajya Sabha. The strength is not fixed. It depends upon the motion passed by the parliament. Parliament decides what should be the composition of a JPC. Incorrect. A JPC is always headed by the member of the opposition. This is also not correct because there are ruling party members who can also head a JPC. So which of the above statements are correct? None of the above statements are correct. D is the right answer. Consider the following pairs. Bachchan Singh case deals with death sentencing. It was in this case that Supreme Court said death sentence should be awarded in the rarest of the rare cases. Arnesh Kumar case, which we discussed in the previous episode, deals with bail. It basically says if there is a crime which you have committed for which the minimum sentence, minimum imprisonment, minimum jail term is 7 years or less, bail should be the automatic option in those cases. Arnesh Kumar case deals with bail. And Skara versus Union of India, which we discussed today, the 1993 case, this was when the collegium system was invented by the Supreme Court. So it deals with judicial appointments. The question is which of the above pairs is or are correctly matched? C, all the 3 pairs are correctly matched. Question number 3. if you're talking about child marriages, what are these conventions of United Nations which are agreed, which are signed and ratified by the government of India? Convention on the Elimination of All Forms of Discrimination Against Women. India is a signatory, has ratified this convention. But Convention on the Consent to Marriage, Minimum Age for Marriage and Registration of Marriages, 1962, India is not the signatory, has not ratified this convention. So which of the India has ratified which of the above conventions? A, only one is the right answer. 2 questions for your mains examination. A punishment that is administered in an arbitrary way, that is imposed on some individuals but not on others, with no valid justification for the difference. Why you are giving one punishment to others, different punishment to others, without justifying this difference, is unconstitutionally cruel, just as an excessively harsh punishment is cruel. Because way back in 1764, Cesare Beccaria, an Italian jurist, published his treatise, An Essay on Crimes and Punishment. In that he argued, amongst various other things, that we should give that much punishment to an individual which is dependent upon the gravity of that punishment. For theft, for meager theft, you cannot award capital punishment. You cannot award death sentence. That is why excessively harsh punishment is also cruel. Comment, question number 2. Despite the overall positive assessment of the scheme, Beti Bachao, Beti Padhao, there exist gaps in terms of budgetary planning and the lack of monitoring the success of this beautiful scheme, which was initially targeted at those areas, those districts which have a skewed sex ratio at birth. Discuss. And the final thing, watch out. Supreme Court has now called for the response of the SEBI, Securities and Exchange Board of India, over Adani stock fall. What is going to be the final verdict of the Supreme Court on this matter? Watch out. Second, the former judge of the Supreme Court, Justice Rohinton Fali Nariman, he had said that Supreme Court collegium should ensure that their recommendations to the government are accepted by the government in a time-bound manner. As of now, if the collegium has recommended that a judge of a high court should be transferred from one high court to another high court, within what period should this recommendation be accepted by the government? There is no timeline. And that's what the Law Minister, Mr. Rijiju, has said. There is no timeline for the transfer of high court judges. But will collegium system impose a time limit within which its recommendations are to be accepted and approved by the government? For that, watch out. That is it for our session this week, where we have covered 4 important topics from the previous week related to Indian polity. And if you have liked this lecture, don't forget to press the like button. Let me know in the comment section whether this 1 month of polity this week has been of any or some help to you. See you again next Saturday, 8 o'clock, with another fascinating discussion on some of the topics related to the world of Indian polity. Thank you. Stay safe. Good night.